there was a mention of if there is a conviction in this matter, there is a mention of sentencing, which I'm assuming there'll be some type of people may want to speak. I know if there is a conviction on my half, people would definitely want to address the court. There'll be a lot of affairs that need to be put in order, obviously on my side. If it pleases the court, if there is a conviction in this matter, I would like the sentencing to not be so quick. I'm asking if it pleases the court for the sentencing to be held off into a later time, not a day or two or a week, just so that affairs can be put in order properly, and so that the people that want to come in and speak will have the opportunity to address the court.
I think that's a fair request, sir.
If that pleases.
I think that's a fair request. I thought about that more overnight, that in the event there is a conviction, that I would like to give the parties an opportunity to do that. I have no idea how many people would want to speak. My inclination would be, again, and this is not set in stone, if there is a conviction on any of these counts, I may ask the parties to just come back in on Monday, October 31st, with kind of a proposed plan of how many people do you think will speak on your behalf, how long do you think it will take, so that I can look at my calendar and then set aside the appropriate amount of time. I certainly don't want to rush anything, and I think that's a fair request that you're making.
Thank you.
All right. So with all of that then, sir, subject matter jurisdiction, I decline to address that further. I stand by the written decision that I've made previously. As far as the rulings made yesterday regarding your ability or inability to present further testimony and witnesses and to testify yourself, the court did make various rulings and findings that you had forfeited your right to do so by conduct. I'm not going to further explain the law or these prior rulings to you. I stand behind them, and I believe I made a very, very clear record. So to the extent that you are asking me to reconsider any of that, that's how I would interpret your statements here today. I decline to do so.
So, Your Honor, would that be, that's still not, I have no understanding to why I wasn't given the opportunity to place certain things into evidence. I have virtually nothing, zero evidence that I was able to place into evidence. Nothing.
I disagree with that, sir. You called, I think, 9 witnesses on your behalf on various issues, including the honking of the horn, the window tinting. You cross-examined many of the state's witnesses about police barricades and the presence of police. So you did present evidence.
I'm speaking to the terms of everything that Your Honor asked me to do. You told me to put everything that I needed to present to the courts in writing. You made that ruling. You told me that's what I needed to do. I did that.
Mr. Brooks, you may have interpreted that. I did not require you to do that. As far as evidence in the case, I very expressly told you there are rules of procedure and rules of evidence that govern exhibits, testimony, witnesses, etc. What I told you is that any requests that you have related to the case, if it's a motion, be put in writing. I specifically referenced the statute 80201 regarding how a motion is made and what it should contain, meaning it has a very express request for relief and states the law and the facts upon which the request is being made. Again, I'm not going to revisit the prior rulings. I stand behind them, and to the extent that the record does not have, meaning the record before the jury and the evidence does not have certain pieces of information, evidence or testimony that you wanted to present, you forfeited that opportunity yesterday based upon your conduct.
How did I forfeit the opportunity?
Again, I'm not going to revisit that, sir. What I will tell you is this.
How did I forfeit the opportunity?
This jury is here
to be able to place into evidence.
Mr. Brooks, I'm not going to debate this further.
I'm not trying to debate. I'm trying to understand.
To respect the fact that I've made rulings.
Your Honor, that's you made a judicial determination. It's not my job to explain them to you. I'm not asking you to explain anything. You're misinterpreting what I'm trying to ask you and trying to tell you. You're misinterpreting it. With all due respect, Your Honor. When you tell me this is what you need to do, I'm going to take it by what you're telling me that I need to do. If I needed to make anything request-wise or anything that I needed to present to the court, it has to be in writing. You told me to do that. I did it. You also brought up when I asked numerous times before when would I have a chance to present things into evidence, you told me we were not at the evidentiary phase of the trial yet. So I took that as saying, okay, well, at some point I will have the opportunity to place things into evidence that need to be put in evidence for the record. So I'm not understanding how a decision can be made for me to actually forfeit being able to put things into the record that need to be placed into the record. All these things are things that, quite frankly, allow me to put on a defense. Things that need to be known, things that should be in the record as far as filings, as far as ICFs that I was told to by you to address certain ICFs either to you or to the clerk of courts, which I did, and received copies for all of them except until last week. It was a few of them that I didn't receive copies for that I'm still wondering why I haven't received those copies when I received the copies of all the ones before that. But in terms of that, I did what Your Honor asked me to do. And these are things that were part of my defense that needed to be placed into the record. So where my confusion comes in is not being able to place those things into the record. Things
Mr.
that clearly help my defense.
I stand by my ruling. I'm not revisiting it. To the extent that you claim lack of understanding or your lack of consent, it's been made abundantly clear on this record your position on that. I'm not revisiting it. I'm further advising you that when this jury comes out, I expect that you will honor the decisions that were made, not agree, but you will honor them and not interrupt the court or these proceedings as I instruct the jury.
So how am I supposed to put these things in the record that need to be in the record?
Mr. Brooks, I'm well aware of the effect my ruling had, and I'm not going to debate it with you further.
I just want to know, how am I supposed to get these things on the record? How am I supposed to, because the filings that I gave, you actually filed and gave me the copies back. So are those in the record?
Mr. Brooks, I'm no longer going to talk about this.
I'm just seeking to understand.
Mr. Brooks, I cannot explain procedure or evidence,
the filings that I filed,
rulings, or
I'm
the
asking
law
a question,
to
Your Honor.
you.
I'm merely asking a question. The filings that I presented to Your Honor.
Any filings with this court are in the court record. That does not mean they're evidence, sir. And I've told you that
That's not what I'm asking. I'm asking, are the filings part of the record? The filings that were filed and timestamped, that were notarized, that I presented to the court, all the filings, the appearance bonds, the statement of particulars, the notice of special appearance, the court docket sheet, your oath of office, everything that I tried to present into the record. How am I not able to make them part of the record?
So they were filed because you presented them to the court during the course of this case. Anything that was not offered as an exhibit and received during the evidentiary phase is not evidence in this trial.
That's what I attempted to do, and you told me that I couldn't. You told me,
Mr. Brooks, I am bringing this jury
Your Honor,
out.
with all respect, you told me that we were not at the evidence. When I said I have exhibits as well, I have stuff that I want to put into the record. I even asked, I said,
Mr. Brooks.
May I give an offer into evidence?
I'm going to stop you
things.
once again. I'm not going to have this discussion and debate. The evidentiary phase of this trial is closed.
It should not be, though, Your Honor.
I understand your lack of consent. Your objection
so when would I
is
be able to
noted
put?
for the
When
record.
would I be able to put vital information into the record, which I haven't had the opportunity to do?
That opportunity has closed for you, sir.
So you saying basically you're prejudicing my defense by me not being able to present things into evidence, offer into evidence, filings, and important paperwork and documents.
Mr. Brooks, and you
How am I
forfeited
not-
your right to do that by your conduct yesterday, and I stand behind that decision.
I asked
do the
before
following,
yesterday,
sir.
Your Honor.
I'm going
I asked
to do the
this
following.
before yesterday.
You have not honored my request to you that you cease debating me on prior rulings
I'm not trying to
of the
debate.
court.
I'm trying to understand why my due process is being violated.
Mr. Brooks, the record speaks for itself.
No, the record
I am
does
going
not.
to take
It
a
does not.
5-minute recess. When I come back out, the jury will also be coming out. I'm advising you there will be no multiple opportunities where I give you to conform your conduct to the rules of decorum
Well, then
and courtesy.
just hold me in contempt, then, Your Honor.
You are
Hold me in
hereby
contempt, because
advised
I didn't even. I'm trying to
that
seek
if
to
you
understand.
start talking about subject matter jurisdiction or any of these other
It
issues,
needs to be addressed,
or
Your Honor.
in any way
We're not talking
interrupt
about subject matter jurisdiction.
the
We're
reading of
talking
the jury
about
instructions.
why my due process
I
has
will
been violated.
excuse the jury and you will be removed
Your
to
Honor,
the other courtroom.
We're talking about the 14th Amendment,
Right.
Section
I am
1.
taking a 5-minute break. We are
Your
in
Honor,
recess.
I don't
When
agree
come
to a
back out, the
estoppel.
jury
I
will be
don't agree
coming
to a
as well.
estoppel. Your Honor, as a